All right, let's stay with this particular story and speak to Brian Wimpey, Trademark Attorney. Brian, thank you so much for your time this afternoon. The court, saying that there's a lack of urgency here, absence of jurisdiction, and saying that the ANC failed to argue, how the voters would then be confused. What was your reaction to the ruling?
Good evening, Bongiwe. Thank you for inviting me. Good evening to your listeners. I think there's one thing we need to make clear, first of all, we've all forgotten about, is that the Durban High Court said that the ANC failed to appeal against a decision by the Electoral Commission to the effect that, in his view, the public will not be confused between the two logos, right? So the Electoral Court made a decision relating to confusion. This decision was not successfully appealed. When the ANC appealed the decision, they were out of time, and so they were not. So, in fact, the decision by the Electoral Commission stands, and that is that the MK logo and ANC logo are not, the public are not going to be confused. So then the ANC, realizing it, brought the application to the High Court, and the High Court said they don't have jurisdiction because the decision by the Electoral Commission has to be heard by the Electoral Court. So the ANC does, so the Durban High Court doesn't have jurisdiction to hear the matter. But it nonetheless went on to look at the merits and said urgency was a problem. And this is one of the big problems that no one's really looked at, is that trademarks are registered in various categories. The trademark that the ANC has taken assignment of from the Legacy Project is in Class 41. Class 41 relates to education and entertainment, not to political campaigning. In my view, and I'm sure plenty of other trademark attorneys will have the same view, is that trademark, the MK is using the trademark, the warrior and spear device, whether it's confusingly similar or not, in relation to political campaigning. The trademark does not cover political campaigning. This is critical because trademarks are only infringed when it's exactly the same goods or similar goods or services. Is that understood on that issue? So that's one of the issues that, number one, they have to get past the decision of the IIC, which has not been overturned. Number two, they don't have the right trademark because the trademark doesn't cover political campaigning, it covers education. And also the assignment of the trademark cannot be retroactive against third parties. So the ANC's got a number of issues that have to overcome to persuade a court that there is an infringement, that the trademarks are confusingly similar.
So, Brian,
yes, sorry.
Pardon me, what does it then mean? Because they're planning to now approach the court, seeking a leave to appeal, then listening to what you're saying.
They're going to go I suppose, straight to the appellate division. I don't know. They've got the route of either going to the full court in the KwaZulu-Natal or to the AD, I think, if my memory serves. But they've got this issue. What happens if the court says, look, I agree that the court didn't have jurisdiction, so you're non-suited? And that's the thing that I think they're going to have a problem with. Because if the court is correct in saying it doesn't have jurisdiction, because the decision of the Electoral Commission was in fact a decision about confusingly similarity, and it said there's no confusion, then how can the Durban court have jurisdiction if that original decision by a state person has not been overturned?
So does it then, a few days ago we saw reports, containing a CIPC document that, of course, Legacy Project ceded the uMkhonto weSizwe trademark to the ANC. Does this have any bearing at all on how things shape up going forward, or is it simply going to be the case that's before the courts right now that is also then decided when it comes to appeal processes?
It's going to be exactly the same issue. That if the court finds that it has jurisdiction, the Court on Appeal finds that the Durban Court had jurisdiction and it's not blocked by the ISC decision. Then the question is, are the trademarks confusingly similar? And I agree with the court I quote. The original court is that the trademark is registered for Class 41 services, not for political campaigning. Therefore, there's no trademark infringement.
Now, when it comes into...
And the court said that, so I can't see the AD overturning that.
So then when it comes to the devices then, I mean, the logos, when you look at the two of them, there are, of course, some differences. You look at the size of the spear, where it is, put on the logo. Give me your sense when you look at the two of them and the similarities.
This is the issue. It's irrelevant whether they're similar or not. The fact is it's in the wrong class.
Yeah.
So if I had to say to you, in my view, let's go back a step. The court I quote said the South African voter is not the South African, a reasonable purchaser of a packet of sweeties at the shop, right? The South African voter is a lot more clued up. So the South African voter is not necessarily going to be confused, especially with the history. The South African voter is clued up about what's going on, knows that there's a party called MK, knows there's a party called ANC. So even if the devices are confusingly similar in the normal sense, the court may be correct in saying, but in the political sense, in the turmoil of political clashing, the people are going to know that they're not going to be confused. They're going to say the MK is its own trademark, the ANC is using a similar trademark, but they're going to know, they can differentiate, right, between the two, because they are more political aware. They're aware that MK's mark, they're aware that it's ANC's mark, there's not going to be confusion. But on top of that, the ANC have to show that they've registered, that they've got the mark in the right class. But they don't. The mark is not registered for political campaigning, and that's a major problem. Whether a court finds the two marks are confusingly similar or not, the issue is there going to be confusion? Well, there can't be, because the mark is for education, not for political campaigning. Am I making sense to you?
Brian, it's going to be an interesting road ahead then, given what you're saying, and let's see then how things unfold. But thank you so much for your time this afternoon. Do appreciate it. That was Brian Wimpey, Trademark Attorney, and certainly this is a developing story that we'll continue to monitor for you.